For the record, all board members who were here prior to the break have returned, and the board is here, absent only Dr. Bernstein and Mr. Cook, who have been absent all day. The next matter on the agenda is case number 14-183. 182, I'm sorry.
It's a typo on my side.
14-182.
Yes.
What happened? Did Norwich not show?
Yep, Norwich did not. I know which way. So
Oh, that's
we
okay.
defaulted. That's the one the question over.
Okay.
Chief, why don't you? Can you just move over? A seat?
Absolutely.
Okay. As you heard in the opening statement, you both are entitled to my opening statement. You both are entitled to an opening statement if you wish. You want to make an opening statement?
Good afternoon. I just wanted to introduce myself. I'm a relatively new chief for the town of East Hampton.
Congratulations.
This is one of my first reviews since my appointment back in May. I'm here to provide an open opportunity for the appellant to make his case.
Okay, thank you. So you have a right to make a brief opening statement if you wish. You want to make an opening statement?
No, sir.
Okay. All right, Chief, if you would state your name, rank, and who you work for the record. The issuing authority has a burden of proof, so you have to establish your case, sir.
Absolutely. My name is Sean. Last name is Cox, C-O-X. May 2nd of 2013, I was appointed as chief for the town of East Hampton, Connecticut. Previous to that, I spent a little over 20 years with the Connecticut State Police. I've had training and experience in reviewing pistol permit applications, and both as a trooper and now as chief. In reviewing the appellant's case, I looked at both our in-house records and as well as his application. What concerned me or gave me pause was the appellant's admission, for which I admire him for being honest, were two arrests of a criminal nature, one operating under the influence, the second possession of a controlled substance. Those arrests were made by other agencies than ours. It did not have access to those records. The DUI seems pretty self-explanatory in nature, given the elements of the crime, which would be operating motor vehicle while under the influence. The possession of a controlled substance is what also gave me cause. One, in that it was just over 3 years before his application to our agency, but also in the fact that I don't know what that substance was, and I felt that before, given close proximity to that arrest, it gave me pause in granting this application for suitability. However, I definitely wanted the appellant to have the opportunity to explain himself in front of the board.
All right, sir. Thank you. Do you have any questions of the witness, sir? This is not time. You'll get an opportunity to present your side, but
Okay.
now it's questions. Do you have questions of the witness?
No.
Okay. Does the board have any questions? Attorney Fishbein.
Chief, is it true that, am I to understand that you have absolutely no information for this board as to any events involving this gentleman that would bear upon his suitability or insuitability to have a pistol permit?
I looked at his application process as a whole, and when I looked at his disclosure for the Portland arrest, which was nollied in 2006, and likewise I looked for the possession of controlled substance, which he also admits was nollied.
So you would agree that you have no facts about the underlying cases that you denied this gentleman a permit for, other than an arrest?
Other than the arrest, no, sir.
You have no convictions against this individual?
I do not.
So I have to ask, why was he denied a permit?
My concerns were ability that both of those arrests involved substances, one being a controlled substance, the other being the allegations of an abused substance. I don't think the process is a rubber stamp process. I can tell you that I don't reject many applications, but in this particular case, this one gave me pause. And I thought it better that it go to the board than just be left to my
So
decision.
under the DUI charge that you held against this gentleman, what product or what was he alleged to have consumed or be under the influence of when he was operating a motor vehicle?
That I don't know.
I think my point is clear. Thank you, Mr. Chairman.
All right. Chief, you understand you have the burden of proof here.
I do, sir.
Further questions to the witness?
Chief, did you ask the appellant about those cases and what the underlying incidents were?
I did not, unfortunately, being the chief cook and bottle washer where I am, I don't have the luxury of assigning to subordinate personnel these types of matters. I have to give appropriate time and place to all responsibilities. So I did not. I thought this may be the better venue for him to plead that case.
Why?
One, he would be under oath. He would not be under oath in my office, and I would want to always provide the encouragement for a truthful answer.
So do you have any reason to believe, based upon this gentleman's record, that if you were to call him into the office and sit down with him in an afternoon, that he would not give you truthful answers?
I don't, but I felt that this was the better venue for that.
Why?
Again, because we both swore an oath to be truthful here, and I thought that should something come about, or should there be a mistruth, at least I would have venue to hold him accountable for that.
Mr. Chairman, I make a motion that we find for the appellant.
Motion to fine for the appellant due to the lack of sufficient evidence on behalf of the issuing authority. Is that motion seconded? Again, I'll second it for discussion.
The burden is not on the appellant to sit here and explain. I mean, this case has been sitting on our docket for months now. So this gentleman has been without a permit, based upon absolutely no information in the possession of the issuing authority other than someone is arrested. And at least as of this morning, we are innocent until proven guilty in this country. And I'm baffled.
I'd have to confer, Chief. I understand that the tendency. We'll let the board make the decision. I'm not too sure that I'll deny it. No, to go up and let the board make the decision. I can understand that, but the rules are such that there has to be sufficient evidence presented to the board that the particular individual is not suitable to be granted a permit. With the evidence that's presented, and I don't see any other witnesses, so I presume there are no other witnesses. In my mind, just isn't sufficient. Is that, well, there was a DUI, there was a substance abuse. I don't know what the substance is. I don't know how much it was. I don't know if he was using it at the time. I don't know if he had a permit at the time. I don't know if he had a weapon with him at the time. In my mind, just isn't, with all due respect, sir, it just isn't sufficient to establish that this particular individual is a non-suitable person. If he had the burden of proving that he was a suitable person, that would be a different story. I'm not inclined, unless the other board members disagree, which wouldn't be the first time with me, I'm not inclined to make this appellant testify against himself, and that's what we'd be essentially doing. Asking him to testify would say, well, we don't have any evidence, but let's see what you have to say. Maybe you may slip up and we can find something. Well, this is not an exercise in a fishing expedition. This is a decision-making exercise, and we have to make our decision based on the evidence presented. And the burden of proof lies with the issuing authority, and I don't see any evidence here at all that would indicate that this man is unsuitable. But board members are free to comment. Any further comment?
Yeah.
Attorney Greer?
With great respect for the chairman's acumen, wisdom, and knowledge of the law, it seems to me that the arrest which the appellant admitted to for DUI and possession of a controlled substance at least raised the issue. Maybe the chief should have taken time out from his other duties to dig into this further, but I don't really have a problem with him raising a red flag and suggesting that the appellant sort this out in front of us.
But nonetheless, the disclosure to the appellant's credit, he didn't have to disclose either one of them. If they were disposed of in the fashion that he says, nollied cases, he doesn't have to disclose. So to his credit, he gave that information to the issuing authority. If anything, he gave them more information that they were entitled to that they didn't even utilize. So it would have been a legal application without even that information, and the issuing authority wouldn't have even had that to investigate because they didn't do anything, it appears here.
Well, accepting that as a working hypothesis, had he not disclosed it, I guess I can accept that rather reluctantly, but he did disclose it and thereby raised the flag. Whether the chief should have gone any further is something I think we should decide.
Well, I'm willing to say that the chief should have gone further. I publicly am stating that. For public safety, I thought this was important, obviously.
And even I agree that it's important that the department investigates. That comes up all the time. Someone makes an admission, and especially when we're dealing in nollie cases, sometimes it's difficult to get those records. However, if the appellant admits it, you can go to the department, if it's yours anyway, or you can find the officers that were involved at the time, talk to them, get a version of what happened, and all that would be helpful. At the very least, someone should ask the appellant his version of what happened.
Right. The underlying conduct which led to nollie itself is he could have said no, answered no because of the nollies. But the underlying conduct is still justful, and we can look at the underlying conduct which led to the nollie. There's 1,000 different reasons why a case would be nollied, and the conduct itself is something we can look at to determine whether or not an individual is suitable. And we just don't have any of that. And I think asking him to testify here today is only asking him to incriminate himself, if anything. Right. So we have a motion that's been seconded. Go down the line. The motion that's been made and seconded is to rule on behalf of the appellant due to the issuing authority's insufficient evidence. On the motion itself, Colonel Overturf. Yes. Attorney Greer.
No.
Attorney Fishbein.
Yes.
Chief Rollersweet.
Yes.
Liz Johnson.
Yes.
And the chair votes yes. All right, sir. The appellant, the motion carries, and the appellant wins, for lack of a better term.
Thank you.
Thank you, Chief. Appreciate it. Thank you.
Dig a little deeper next time, Chief, I guess.